The first consideration should be, are you in a position to financially pay it all? If you are, then you should do so. You can't just try and take advantage of the scheme because it's there. One thing that's really encouraged in the scheme is transparency and the open exchange of information between the tenant and the landlord. So part of the process as a tenant is you're going to have to prove the viability and affordability of your business. So that's going to involve providing a bunch of evidence, as much as you can really get your hands on, just to prove that, one, you've actually been in financial hardship because of the COVID effect of lockdowns, and two, there is enough viability in your business for you to be worth saving effectively. And what we mean by that is basically, one of the principles that's been laid down is that tenants should be protected and prioritised, but not at the expense of the landlord's solvency. Basically meaning that there's kind of an interesting balance to be found. The scheme is still currently not being laid down in law. It's actually before Parliament at the moment, before the House of Lords. So things might change before it actually becomes an official act. But in the meantime, it is important to know that if you are in extreme financial hardship, tenants are encouraged to go to the landlords, be open about that, and see if they'll work with them in the meantime. So the first thing for the landlord to check is whether the debt is actually officially ring-fenced under the Act. So that means that it comes within the period where COVID restrictions were in place. So that'll begin on the 21st of March 2020, and at the most it'll last until the 18th of July 2021. However, it might not necessarily go that long. So for example, the restrictions on shops that were deemed non-essential all stopped on the 12th of April 2021, which is obviously a bit earlier, meaning that there may be more that the landlord can go at by traditional routes as opposed to this arbitration scheme. The other thing that's kind of the flip side of what I was talking about with the tenant's viability and affordability before is that obviously the landlord's solvency can't be risked at the tenant's expense. So this may end up being quite a difficult position for arbitrators to be in, bearing in mind how much the debts might be either way and how reliant either party might be on it. And that's where it's going to come down to how well your evidence is prepared, what evidence you've got, and how well you're represented throughout the arbitration process. Well, the first thing is going to be ascertaining exactly how much of the debt is ring-fenced and how much of it can be pursued by traditional methods. A solicitor can also help in terms of the code and the bill are encouraging people to engage in negotiations beforehand. The goal is not for everybody to end up with arbitration, it's for the parties to negotiate in good faith and try to come to a resolution if at all possible. And if they cannot reach a position they both agree on, then the parties will have to go to the arbitration scheme and will have to accept the legally binding decision of the arbitrator. So solicitors can also help from there in terms of letting you know what evidence to accrue, in terms of what's going to be useful to your case, and they can also arrange a representation for you through the arbitration process. The government's actually already laid down a non-exhaustive list which has a whole bunch of factors which are going to get taken into play. Things like any judgments against you, the debit balance, the performance of the company, the assets, all sorts of stuff like that. So having a solicitor take over will just help you make sure you're formulating your case for the best way for you.